Reflection. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We'll have the reading of the notice, please.
The adjourned organizational meeting of the Marathon County Board of Supervisors, composed of 38 members, will convene at the Marathon County Courthouse Assembly Room, 500 Forest Street, Wausau, on Tuesday, July 23rd at 6 p.m., and the agenda was duly signed and posted.
Thank you. I would like to request everyone please silence your cell phones and any other electronic devices as to not to be an interruption to the meeting, and I thank you for your indulgence. And we'll move on to roll call, and I'd ask everyone to please sign in. All right, thank you, and we'll proceed to item number 6, and I welcome all of the visiting audience that we have with us, including the visiting audience participating on TV. So we'll move on to educational presentations and or reports. Standing committee chairpersons or designees. Any reports by standing committee chairpersons or designees? Okay. We will move on to item number C, consent agenda items C8 through item C13A. What is your pleasure? Motion by Supervisor Drabeck, second by Supervisor Crivelli. Any discussion on those agenda items? Again, the motion is to approve the consent agenda items C8 through items CA1. Any discussion? Seeing none, we'll proceed to vote on the motion to approve items C8 through items CA1. Supervisor Arstead?
Yes, it's not working. Okay, I figured it out. Okay.
All right, thank you. And we'll record your vote as a yes. And we'll proceed. And the motion is carried and is unanimous. Thank you. We'll move on to item number D, motion to reconsider text amendment updates to Chapter 17, Tyler Seehafer. Motion by Supervisor Marash and seconded by... I guess I'll only ask because I don't know the answer to the question. Supervisor Marash, did you vote in the affirmative last time in June?
Yes, I voted in the affirmative last time.
Okay, all right. Okay, so the motion is made and seconded by Supervisor Marash and seconded by Supervisor Conway. Supervisor Langenhan, please.
Thank you, Mr. Chair. Mr. Chair, there have been a number of things that have transpired in the last month since the board acted on this item. The first thing I would like to ask is for Corporation Counsel to detail the appeals process from the Board of Adjustment, the current suit that's currently in front of Marathon County from the text amendment applicant.
Sure. So before this text amendment was brought forth as a proposal, there was a request before our Marathon County Board of Adjustment, specifically relative to the determination of our Marathon County zoning administrator that movement of the home on this particular parcel owned by Mr. Seehafer onto a new foundation took it out of our zoning code regarding the ability to have farmland consolidation applied to it. So that issue was heard by our Board of Adjustment. They denied Mr. Seehafer's petition. An appeal or a petition for what's called certiorari was filed to have the Marathon County Circuit Court review that decision of the Board of Adjustment. That is pending currently. It is still being assigned to a judge, so there hasn't really been any movement on the case, but that issue is pending. That is a separate issue from the text amendment, because the text amendment applies, as I indicated, I think on Thursday, to the entire zoning code, not specifically to the one parcel in question.
A follow-up, Mr. Chair.
Go ahead, please.
Corporation Counsel, is it fair to say, though, that if at the Circuit Court appeal, if the court were to side with Mr. Seehafer, there really would not be a need for the text amendment change to Chapter 17?
Well, the effect of the Circuit Court overturning the Board of Adjustment would be that Mr. Seehafer would be able to proceed, my understanding is, the way he wished to proceed. The text amendment, though, wouldn't be in place, so Chapter 17 itself wouldn't be adjusted as a whole to apply countywide. However, it would, the Circuit Court's decision would apply to Mr. Seehafer directly.
Then one last follow-up, Mr. Chair.
Go ahead, please.
In addition to that information that I wish to offer to the board, I also wish to offer the facts that a town official from the town of Marathon recently, I believe yesterday afternoon, contacted Mr. Seehafer's attorney and offered a third option beyond the text amendment changes and the BOA. I think it's fair to say that you could call it a compromise. I know that the town official talked with that attorney this morning, and that attorney was going to inform Mr. Seehafer of that opportunity. Part of the reason why I'm late this afternoon or for this evening's meeting is because I was waiting to hear back from that town official to understand if there had been any further communication between Mr. Seehafer's counsel and that town official, and there has not been. So in light of those two things, I would offer this to the board. I would offer that this be postponed, this motion to reconsider, until 30 days after the certiorari review is completed by the Board of Adjustment. I think that gives an opportunity for this issue to be resolved without having to change the overall zoning code. I think that it respects the wishes of the applicant, which to the best of my knowledge, with the testimony that Mr. Seehafer offered in the public hearing, is that he just wants to farm. You know, the town of Marathon, to their credit, they're concerned that they don't want their community to be dominated by subdivisions, right? I think that either that compromise or the appeal to the Circuit Court are ways that this can get solved without the board having to reconsider this. And even then, with this motion to postpone, the motion to reconsider would not be out of order. It would still follow our board rules. So there still would be an opportunity to reconsider it if both that compromise and the Circuit Court did not side with the applicant. So with that, Mr. Chair, I would offer that this matter be postponed to 30 days after the certiorari review is completed by the Circuit Court. That's a motion.
Is there a second? Second, okay, just a second. Just tell me when you're ready. Motion was made by Supervisor Langenhans, second by Supervisor Drabek.
Point of order. Did we
order.
not previously have a motion and a second on the table for a vote that we needed to take a vote on before entertaining a second motion?
I'll allow the parliamentarian to respond to that point of order question.
Thank you, Mr. Chair. And I think it's appropriate to address the procedure at this point anyways, so perfect point of order. So the motion to reconsider, a motion to postpone to a time certain can be applied to the motion to reconsider. So a motion to postpone until an event happens or until a specific time after an event happens is in order per Robert's rules. It can be applied just like a motion to amend can be applied to a main motion. The motion to postpone to a time definite or a date certain can be applied to the motion to reconsider. Now, the motion to postpone does need to be to a time definite, and that time definite has to be a time that is going to occur during this session of the board, so during the next 2 years. I would suggest that in addition to utilizing 30 days after a specific event, perhaps you also consider putting a date certain in there, because 30 days after a decision by the court, my experience with courts is that we don't often know how long things will take, and it is possible and reasonably foreseeable that that could occur outside of this existing session. So having an alternative would be in order. The other piece is related to the actual vote on this motion to postpone. So normally the motion to postpone to a time certain is a majority vote. However, we do have a specific county board rule that outlines the process for our motion to reconsider. It does differ slightly from Robert's rules. And one of the ways it differs is that it says that the motion shall be voted on at the next voting meeting. This motion to postpone until a time certain is in effect suspending that particular rule. So I think the proper vote margin for this motion to postpone would be a 2/3 majority vote. That would in effect suspend that particular rule in this case. So I hope that answers your question, Supervisor Marshall, and doesn't create too much confusion, but if you have questions, please, I'm here to answer them if I can.
So the point of order is the motion is in order, but would be looking for some clarification. And when the vote does occur on the motion to postpone to a time certain would require a 2/3 majority vote. Supervisor Jacobson.
I just have one question for Corp Counsel. Would the text amendment, if successful, moot the cert action?
Not necessarily. That would be up to the petitioner. I wouldn't be surprised if they considered the issue moot, but the issue that's being appealed is whether the Board of Adjustments determination about particular interpretation of our zoning code is correct. That issue would still be ripe for the circuit court to decide. However, the petitioner might decide if the text amendment passes that they don't need to go that route. So I can't answer that for sure.
And is there a scheduling order in the cert action?
There is not at this time. The matter was originally assigned to Judge Corbett, who had to recuse himself due to his previous role in this seat. So it's currently waiting assignment of judge at this point.
And what's the standard of review in the cert action? Meaning, what's the circuit court going to look at? Is it going to take a fresh look at it, de novo, or is it going to defer to the Board of Adjustment for abuse of discretion?
That's a good question that I will answer for you in a few moments.
Just a point of also clarification, if the text amendment, we get back to voting on the text amendment, I do want the board to understand that the text amendment does have to go to the Department of Ag for certification also. So the approval by this board doesn't necessarily mean that the Department of Ag is going to approve of that change, because that change is effectively changing the Department of the department's rules. Supervisor Langenhahn, please.
Thank you, Mr. Chair. And this would be another question for Corporation Counsel, but I'm happy to add an alternative time certain part of the motion, but and this is on me. I should have contacted you before the meeting this evening. I apologize to the board. I would ask this: when, in your best determination, could you see the matter being taken up by the circuit court and resolved?
Sure. Again, courts move at different paces, so I can't say for certain. If the action was assigned to a judge today and the judge issued a scheduling order tomorrow, a typical scheduling order would allow 30 days for the appealing party to brief, 30 days for the county to, or the Board of Adjustment to respond, 15 days potentially for a reply, and then at least 30 days for a court decision. So that's 105 days, 4 months-ish, and that's being very optimistic. 6 months seems more on point, but that would be a educated guess.
Sure. See, the part I'm struggling with is that if that appeals process plays out in the appellant's, I might be using that terminology there incorrectly, but Mr. Seehafer's favor, then there's no need to change this code. I think that's really the core of this. Another option would be, what if the town of Marathon and Mr. Seehafer were able to work out that compromise, you know, before that 6-month time frame is up? Let me look at a calendar and I'll get back to you.
Supervisor Robinson, next.
So a question relative to process. So we have a motion to reconsider and we have a motion to postpone. The motion to postpone at this time requires a suspension of the rules and a 2/3 vote. If the motion to postpone is entered after the motion to reconsider is adopted, it will require a majority vote. Is that correct?
I don't.
If we reconsider the issues before us, and therefore a motion to postpone would be consistent with our rules, would it not? The critical time frame for the reconsideration is the next meeting of the county board, the shall.
I'm just reviewing our rule regarding the motion for reconsideration because, as indicated earlier, the portion of that needs suspending at this point, if this were to be postponed, is the requirement that the motion for reconsideration be voted on at the next voting meeting. The rule itself does not specifically require that, or it does not specifically indicate that the vote on the underlying item that's been reconsidered must be heard at the next voting meeting. And Robert's rules, which applies when our rules are silent, does allow a motion to reconsider or the underlying motion to be postponed to a time certain. So I believe, in effect, you are correct. If the board were to first vote on the motion to reconsider, and if that motion is successful, there could be a motion to postpone the underlying issue to a time certain. That would be a majority vote.
Supervisor Lemmer, please.
Thank you, Mr. Chair. I could use just a little clarity because what I'm remembering is CPZ saying, regardless if there's, compromise made with the Seehavers, this needs to be clarified. Chapter 17 has some messiness to it. Is there anybody at CPZ on who could just address that?
We do have the individual from CPZ, Shad. Shad, do you want to try to answer that question? I think the clarification is something different, but I'll go ahead. You have the floor.
All right, sounds good. Thank you, Mr. Chair. So the farm consolidation language did take some work in Mr. Seehafer's case to determine that he wasn't eligible. It could be clarified. We did do a lot of research as far as with that cap as well to determine that his situation wouldn't be eligible for a farm consolidation. It could stand to be clarified some, but ultimately, if that were the case, it would be we'd have to have discussions likely at the committee level to see in which way it needs to be clarified. Right now, we're looking at it from what Mr. Seehafer is petitioning and the language that he has presented.
Vice Chair Dickinson, please.
Thank you, Mr. Chair. So in this postponement and that we're talking about, as I discussed with the chair, with yourself and with Corp Counsel before, I mean, the reconsideration came up in 2019 when there was some issue about whether you were supposed to reconsider at the next voting meeting or you're going to wait, for the session. There was a big to-do about that. The spirit of the motion of reconsideration is to take care of it efficiently and not to continually push out for review of information. And we can even look at our code, and we can look at item 5, which talks about our vote, the reconsideration without the requirement of committee review. So in my mind, I think we have enough information not to postpone. I don't think we should postpone. I think we could go back and forth. And Corp Counsel even mentioned earlier that, this issue is outside of, the text amendment is outside of the Board of Adjustment, and it's outside of what's happening with town officials. So thank you.
Corp Counsel has an answer for Supervisor Jacobson's question that was posed.
Thank you, Mr. Chair, and thanks for your patience. I had to look up a previous brief. So the standard of review in certiorari matters is whether the county kept within its jurisdiction, the county acted according to law, the county action was arbitrary, oppressive, or unreasonable, and the evidence presented was such that the county might reasonably make the order or determination in question. So the circuit court is charged with reviewing the record to apply the substantial evidence test to determine whether the evidence is sufficient to support the administrative body's decision. Does that answer your question?
I already knew the answer to it. I just wanted everybody else to know.
Thank
So
you.
you can't test my legal acumen.
Too many lawyers in the room. Wait a minute. Supervisor Marash, please.
Thank you, Mr. Chair. I apologize. I believe I'm going to make this even more confusing. My motion to reconsider may not be valid because my original vote way back when
That's what I thought.
was to uphold the ERC's decision. So I don't even know if that matters at this point because of the motion to reconsider, but I wanted to come clean before it was too late.
So if I could clarify, the prevailing vote last month was to uphold the ERC's decision. Was that your vote? So you were on the prevailing side?
You were on the prevailing side, so a motion to reconsider from you would be appropriate. Okay, Supervisor Langenhan next, please.
Thank you, Mr. Chair. I've realized that given my inability to predict the future, I'm going to let my motion wording originally stand. It's impossible for me to look at a calendar and get a good judgment as far as when that 6 months is actually going to, well, I won't say when the 6 months is going to occur, but when the court would actually take it up. So I think my wording is sufficient with the motion. I also think that in light of how this issue transpired, that it's appropriate to let the circuit court process came out. Because in my opinion, this text amendment change wouldn't have been prompted if the BOA decision would have been in Mr. Seehafer's favor. I say let that process completely play out before we get to the point where we have to change an ordinance. I don't think that's appropriate. So, yeah, I'd ask the board to please vote in favor of postponement. Thank you.
Supervisor Jacobson, please.
I guess the only thing that we have to consider is, as Corp Counsel alluded to, is the unpredictability of the pace at which the circuit court is going to move. I would ask the Corp Counsel for his opinion. Is it not also very possible that the circuit court could look at what we've done? Should we postpone and say, well, or should we not postpone and say, well, I'm going to wait to see what the county board does, because that can moot this case?
I also am not good at predicting the future, and I don't know if a court would consider that. I would be surprised if a court did consider it, since these are different. They are different subjects, different topics, different issues, but I can't say for sure what a court would do or whether they would consider the board's action or non-action. I wouldn't want to speculate on that.
Supervisor Marshall, please.
Thank you, Mr. Chair. I don't think it's fair to the petitioner to delay another 6 months or up to 6 months and then bring this back. I think that they have gone through this through rezone with the town. Then it was brought back on a technicality, and then there was a new vote taken, which they really were granted a rezone initially, brought back on a technicality. Then it was voted on again for a rezone and denied 5-0, with the one person who did send us an email, Bernie Dick, did not mention that he is one of those town officials who voted against a rezone for this petitioner, as well as Chair Keith Longenhan. So I think it's important that to provide this petitioner closure.
Supervisor Conway, please.
I would just agree with Supervisor Marshall and add that if you let it go through the courts to play out, lawyers typically are not inexpensive, and I don't think this would be a pro bono case, so I think that would be also unduly harming the petitioner. So,
Any other discussion? Any other discussion? So the motion before the board is a motion to postpone till the circuit court reviews this, does the certiorari review, and take this up no later than 30 days after the court's completion of the certiorari review. Is everybody clear on what the vote is? The motion is to postpone to a time certain to no less than 30 days after the certiorari review is completed and a decision made by the circuit court. It is a suspension of the rules and does require a 2/3 majority vote. Everybody clear? All right, we will proceed to vote. And we'll proceed. And the motion fails. And so we are back to the motion to reconsider. It is before the board as a motion to reconsider. And that is now debatable. We are at the debate stage on the motion to reconsider. Any discussion? Supervisor Marshall, please.
Thank you, Mr. Chair. I just wanted to recap. The landowner has taken this land that was not previously being farmed and put it to agricultural use. He got all the necessary permits to move the 100-year-old farm from the middle of this field to an untillable corner. a part of land that could not be farmed. He converted that driveway to a tillable land, increasing the agricultural acres. All this is in the spirit of farmland consolidation. Again, when we talked to Shad, he said one of the recourses could be a rezone. The petitioner has already tried rezone with the town. That did not work. When he sought farmland consolidation from CPZ, they then told him any movement of a house from one location to another is deemed a new home. A new home. A 100-year-old farmhouse being moved is now deemed a new home. 3 townships are okay with this. There is 1 township who is not. And like I said, the only email that I received, and I believe the whole board received, was from someone who called it a citizen letter, but he also is a town official who voted against the petitioner getting a rezone. I ask you, please approve this text amendment. The farmer has done the things necessary in the spirit of the farmland consolidation law.
Supervisor Langenhan, please.
Thank you, Mr. Chair. I'm not going to debate the text amendment just yet. I don't think we're at that point. I think we're at the point for the reconsideration piece. So that's fine if this board wants to reconsider something like this, but I just want to, recap something, which is that I don't know what exactly changed in the last month for something like this to be reconsidered. I don't know. I'm fine with it being reconsidered, but I hope that somebody can give me a really good reason of why this is the case. I thought there was finality in this process, and I'm happy to debate these text amendments further if we get to that point. Thank you.
Supervisor Boots, please.
I'll just reiterate what I said before. I really have nothing against Mr. Seehafer. Don't really know the man at all, and I can appreciate what he did. But this is what I will say. Being a town official for 10 years in the town of Texas, we didn't go through county zoning because of this right here. Because guess what? If it goes back in the township's hands, you're going to see a mass exodus of townships jumping out of county zoning if we start telling townships what to do with their land. So town of Texas right now, we don't have to even ask your permission to do anything. And it was a 5-0 vote now by a township. We're going to say, nope, we're doing it this way. So be careful what you wish for.
Vice Chair Dickinson, please.
Thank you, Mr. Chair. Just in regards to the motion to reconsider, I guess I would say we put this into the rules so that people would have the opportunity to reconsider based upon the information they feel is relevant to them. I have no idea. I did not vote. I voted in favor of the text amendment, so it wasn't something I would have reconsidered. But it's in our rules, and that's what we're doing. And I do think, given all of the information, even the motion to postpone, looking for more information, still brings us to the point where I think, as a county board, we should at least have the discussion about what the vote is going to be. And the motion to reconsider, in that regard, we should be affording ourselves the opportunity to have further discussion on it. So I think the motion to reconsider makes complete sense. We can talk, like other persons had said, we can talk about that other information after that fact, but I do think it makes sense. Thank you.
Supervisor Marash, please.
Thank you, Mr. Chair. The reason I am in favor of reconsideration and the difference that has happened since the original vote, because normally I would be completely in favor of upholding a township's decision. With that said, there's a lot that has come out that we didn't know previously. We didn't know all the parties that were involved. I didn't know who the chair of the town of Marathon was, and didn't realize that his son was the head of ERC. And I'm not saying anything, is not kosher with that situation, but it would have kind of been interesting to know those facts. All the hoops that Mr. Seehafer has jumped through. Originally, I was under the impression that he didn't follow all the right zoning regulations and didn't get all the permits and do all that, and that's not the case. He did do all that. So that is why I have chosen to put this up for reconsideration.
Any other discussion? Again, the motion before you is a simple majority motion needed to approve. A yes vote on the motion to reconsider puts us back at the point where the motion was to, the motion was to uphold the ERC's decision to deny the text amendment. That's a motion, so a vote yes will put us back at that point prior to the vote. Is everybody clear what happens? So if we vote to approve the motion to reconsider, we're back at the point in time that was just prior to the vote on the text amendment, upholding the ERC committee's recommendation. Any questions? So a yes vote brings us back to reconsidering, and we're at the reconsider point of where the board was prior to taking the vote to support the ERC's decision. So the vote, it's like the vote didn't happen. That's where, if you correct. A yes vote will put us at that point. A successful vote on the board floor will put us at that point where we are now going to debate whether we support the motion that was on the floor. Everybody clear? Any other discussion? Okay, we'll proceed to vote. And we'll proceed. And the motion is carried. We are now at the point where the motion on the floor is to support the ERC's recommendation to not approve the text amendment. That's where we're at. And so we're at the point of discussion then, at this point. Vice Chair Dickinson, please.
Thank you, Mr. Chair. I just want to clarify. The resolution that is before us indicates a text amendment. And the agenda seems to say that we are voting on the text amendment. So the ordinance 024-24 says, now therefore be resolved, the County Board of Supervisors does ordain the General Code of Ordinances for Chapter 17. So I want to make sure that we're clear on what we are voting yay for or nay for, because I am willing to make a motion to approve the changes as in the resolution.
I look to the Corp Counsel because I don't believe that motion would be in order in light of the motion to reconsider, because we're reconsidering the motion that was on the table.
So we are back at the point of last month, and statutorily, when we have a text amendment to the county zoning code and a recommendation from the county's zoning committee, in this case ERC, to deny that text amendment, the action then comes before you as a county board. You have the choice of upholding the ERC's determination and denying that text amendment, or directing the item back to ERC to have an ordinance drafted consistent with the petition. There is a draft ordinance in the packet. In reviewing that draft ordinance, it does indicate the recommendation is that the petition be denied as applied for, and it doesn't, I mean, the now therefore be it resolved doesn't, it's not in conformity with the petition, so I think this isn't, statutorily it looks like it has to be sent back to ERC only for them to provide you with an updated ordinance consistent with that petition. That's how I read the statute. If this ordinance before you had, was completed in that fashion, I think you could vote on it, but I don't read it that way. Does that make sense?
So the motion then is going to be, motion and second will be to agree with ERC, which is a no to the amendment, right? So then voting no, the majority of folks voting no would then take the ERC's decision. It would send this back to them to fix the resolution, to bring it back to our board for approval.
Yes.
Okay.
Supervisor Langenhan, please.
I guess I want to make a couple points, and now, given the recent questions, I have more questions. I guess my first point would be, and I know in the past when we've had reconsideration votes and they've essentially reappeared like they were acted on the prior month, correct? For example, on the display, we would have the prior person who made the motion in the second, right? Okay. That's the first piece of clarity. The second point of clarity is regarding the process I think Vice Chair Dickinson referred to, which is that a vote in the aye upholds the ERC decision, right? There would be no text amendment. A vote no, you're saying Corp Counsel would refer this back to the Environmental Resources Committee for further action, specifically to amend the resolution so that it includes the text amendments?
So a no vote would direct ERC to approve a resolution consistent with the text amendment petition and forward that to the board. So essentially, it directs ERC to send to this board an ordinance consistent with that text amendment. I don't read the statute to give ERC any discretion in that, other than creating that ordinance.
So, and follow up, of course, maybe in the meantime between this point and then the circuit court can act on the BOA issue. Anyway, I want to make a couple new points then. Supervisor Boots had brought up what I believe is an excellent point regarding the relationships that we have with those county-zoned towns. Somebody had mentioned earlier that there were 3 towns that were in favor of this. I will say this. 1 took no comment on this, and the other 2, to the best of my knowledge, do not have any land under contract for farmland preservation. So I do not believe that it is unreasonable for the town of Marathon, which is exclusive ag zone, to be given more preference with this issue because it is coming from their town. And to Supervisor Boots's point, with the 18 or 19 towns that we have under county zoning, they will pay attention to this, they will see this, and it might not be this year, it might not be next year, but over time, where you will have decisions that will come from county zone towns, and if the county board were to strike those down and not agree with the towns and not give preference to them and their decision, local authority, they will start to leave. Some of you might view that as a good thing. Hey, we won't have county zoning. That's just one less thing for the county to have to put county tax levy dollars for. County zoning saves this county and its taxpayers a lot of money every year because we don't have 19 separate zoning administrators administering code throughout this county, right? We already have a situation where we have towns that are under county zoning that can submit feedback or that can submit changes under the code. Town of Plover is a perfect example with the storage containers from, I believe, last month. I think it would be a disservice to start to go down that road to our residents. I really do. The other thing I think this does is it signals to people that, hey, if I don't get a rezone through the first time, that I'll just change the code myself, right? And I talked a lot about finality in the zoning process last month, a lot. I don't think this helps with finality at all. I think this keeps delaying the issue, which it sounds like this county board doesn't want to do, by the way. The other thing I want to mention is that this issue, unfortunately, is dividing the town of Marathon. It's dividing it by neighbors. It's dividing it by families now. I think everybody in the town of Marathon, because how they value farmland, doesn't want subdivisions popping up in their town. And I stand by what I said. Some of you value housing. I'll tell you something. Right over the hill from me in the village of Marathon City, we like to joke that's the 400 block. They've got a block in the middle of their city that's totally undeveloped. Why can't they put an apartment building up there, right? They need housing so bad, put it up there. Don't put it in your prime farmland. That doesn't make sense. The other thing I'll add is that with this, I guarantee you will have people playing games And you'll have people that'll be separating off parcels and moving buildings and having more development, which is something that the town of Marathon does not want. They want farmland. They do not want more development. I talked to people yesterday, they said, we don't want subdivisions in the town. I totally respect that. I brought those interests to the board and I stand by them. I would urge you all to vote with the ERC, vote yes on this, and I'm happy to continue debating this because I truly believe in this. Thank you.
Supervisor Conway, please.
I spent a bit of time on ERC my first time here. Those 3-4 hour meetings are in my heart still. I don't see this as a negative thing, going against townships. Never did I ever want to do that. I did not do that one single time. But we also don't want to be a rubber stamp. We can't just, forward everything exactly as they say every single time, because then there's no reason for it. So on occasion that maybe, there's a little bit more information that comes about, that we could go against them. And it's not that we're going, it's not like we're going against them like, it's an us versus them thing, but the oversight that we have goes further than what they might have, perchance. So I voted to decline it last time, but I'm going to vote in favor of the petitioner this time because I think it just makes sense.
Supervisor Marshall, please.
Thank you, Mr. Chair. The moving one home and creating more farmland is not creating subdivisions in the town of Marathon. I don't understand why the town once approved the rezone, brought it back on a technicality, and 3 individuals changed their vote. It was previously a 3-2 vote, and after the technicality and it came back, it was a 5-0 vote. It does not make any sense, but again, what he has done with the land is in the spirit of farmland preservation. And I will be voting no to the amendment or to the resolution.
Supervisor Sandalski, please.
Thank you, Mr. Chair. I just wanted to say the reasoning why I brought this back for reconsideration is, like myself and several other board members and other people in the community didn't fully, it was a lot of misunderstanding throughout the process of getting this text amendment going. And I don't see anything bad about this text amendment. It isn't about building houses and subdividing and all this. It's just about moving a house or moving in like a farm to make it better. It's not, I don't foresee a lot of people going out and doing all this work to move houses and try to make it better than they're not going to, it's not about building houses. So that's not in the amendment. I just wanted to clarify that. Thank you.
Supervisor Langenhan, please.
Thank you, Mr. Chair. And those previous couple comments, I think I can't help but smile because here's probably the punchline to this entire process. That home could have been moved, and there would not have been a requirement to section it off. There wouldn't have been a requirement to change the text of the zoning code. I think that somebody could just pick it up, move that house without sectioning it off, right? Here's the thing. The reason people section that off is because they want to sell. The remaining acreage, they can combine parcels. You end up being over that 35 minimum acre. Suddenly you get into a situation where you go from 1 more allowable buildable lot to 2, right? That's the concern. That you can't argue with. That's math. Thank you, Mr. Chair.
Any other discussion? Vice Chair Dickinson.
Thank you, Mr. Chair. And I just wanted to, before I make my comment, I do want to point out that we do have a limit on the number of times someone can speak on a motion. So I'll just bring that up and mention that. I think this is my second time on this one.
We're keeping track of that.
Thank you very much. I appreciate that. I have 3 townships that I represent. One of them is McMillan. And McMillan has spoken in favor of this. So I want to clear that up. The other 2 are Old Plain and Brighton, and Old Plain is in favor. And what I mean by in favor, they're in favor of what Mr. Seehafer and the text amendment is bringing forward. Now, is it the entire township? No, it is individuals within the township who have spoken. Second, it seems to me most of this issue is about whether you have a new house or an old house, and whether the movement of that. If you build a new house or it's an older house, et cetera, to a smaller parcel, it kind of changes the nuance of it all, which is ridiculous. It's utterly ridiculous. Third, if ERC and CPZ had come up with this exact text amendment, there would be no question about this whatsoever. The only issue that arose from this, and a couple people have commented on this, is that a citizen brought forward the text amendment, and that's just something that we don't do, and we don't want to set a precedent of that. Well, that's kind of silly, and Supervisor Conway spoke a little bit about that. We're not here to be a rubber stamp for the ERC. We're not here to be a rubber stamp for the town of Marathon or McMillan or anything. Our responsibility is we are the authority. We are the one who makes the decision. We are the one who decides what the text of the ordinance is going to be based upon the information that we have. So I just want to point those out. I don't think this sets a bad precedent. I really don't. I don't think we're losing farmland. I really don't. And at this point, I just think it's really good that we have the good, honest discussion, and then we have citizens willing to bring forth amendments that maybe we didn't really consider. I think that's a good thing. Thank you.
Any other discussion? Any other discussion? Everybody understand the vote? A yes vote will uphold the recommendation of the ERC committee, and that is to deny the text amendment. A no vote, as Corp Counsel has alluded to, forwards the resolution back to ERC to draft an ordinance that is consistent with the request for text amendment. Now, the board rules say you can speak to an item 3 times. Supervisor Longen, I think you have spoken to it 3 times.
Yes,
So
sir.
this will be the
Yeah.
3rd time.
Yeah, I'll make this one
This will be
count.
the 3rd time. Thank you.
One more thing I forgot to add. That point about my dad being the town chair of the town of Marathon. I reviewed my situation, determined I did not have a conflict when I participated in the ERC activity. Afterwards, there was a letter that was sent from, I believe, attorney representing Mr. Seehafer alleging a conflict. I went to the corporation counsel, gave him all of my information. He also determined that I did not have a conflict. So in the interest of transparency, I'll throw that out for the board. I guess I should also mention that I guess my brother was the school board president for the Marathon School District like 13 years ago. But while we're airing things out, I figured I'd throw that out there for folks. That was a joke. Anyway, a question regarding the process. Mr. Corporation Counsel, what happens if this goes back to ERC and the resolution is proposed to adopt the text amendments and the ERC votes it down? What happens then?
I read the statute to not give ERC discretion to vote it down. You have to forward it to the county board consistent with the petition. So
No, you're the attorney. I trust you. Thank you.
Any other discussion? Any other discussion? So now we're at the point to vote. Is everybody clear what you're voting on and how you're voting? Again, a yes vote will uphold the recommendation of ERC. A no vote will send it back to ERC with instructions to draft an ordinance consistent with the text amendment request. Everybody clear? We'll proceed to vote. And we'll proceed. And the motion is failed, and it is sent back to ERC. Moving on to item number 13, resolution, Human Resources, Finance, and Property Committee, reauthorizing of self-insurance for workmen's compensation, resolution 32-24. Motion by Supervisor Cavelli and second by Supervisor Langenhan. Any discussion? Seeing none, we'll proceed to vote. The motion is to approve the reauthorization of self-insurance workman's comp, Resolution R 32-24. No. Yeah, it's coming up. Can you change the text? We'll just ensure that the clerk's going to change the text, and then we'll change the text on the next one. Again, this was a reauthorization, excuse me, that was in the consent agenda. Me bad. I'm sorry. That's your chair's mistake, sorry. That was in the consent agenda. And so we are down to item resolutions, and we're down to item F. And that is the approval of the budget amendment to allocate the $50,000 in American Rescue Plan, ARPA funds, to participation in the 2024 Uniquely Wisconsin Program, Resolution 30-24. I apologize to the board. That is a motion by Supervisor Cavelli. Correct. As a budget amendment does require a 2/3 majority vote. But I failed to go, I need to go back to, was there any discussion on the agenda item? Before we show the vote, is there any discussion on the agenda item? Vice Chair Dickinson, please.
Yeah, my only question, so this is still ARPA. I would assume this is the last ARPA movement of money, is that correct? Because that would be done by the end of the year, is that correct?
This is part of the ARPA funding that is still, that has been unallocated. So at this point, there's still unallocated ARPA funds that has to be spent or allocated by December 31st, 2024. We have roughly $2 million sitting in ARPA because some of the allocated funds have to be reclaimed because the projects didn't go forward.
Okay. So based upon that, my question is, has it been discussed in HR Finance or anywhere about continuing this program in the future as part of a budgetary item?
It has been discussed, and there's been discussion about having potential discussions with other entities for use of room tax and partnering with them as we potentially move forward in 2025. Okay, Supervisor Robinson.
In response to Supervisor Dickinson, we are at our next meeting on August 7th trying to reconcile where we are with the ARPA dollars. Particularly, we're going to be bringing in August the capital improvement plan. I think ARPA dollars will be a critical component of that. So we're going back, for instance, Frontier with their withdrawal of their Public Service Commission broadband grant freed up $933,000. We want to make sure that we can recapture as much of that as possible and have a better idea. And we're closing out projects, so we'll be able to sort of, pull all of that together in context of the budget.
Any other discussion? Okay. We've removed, we have the motion by Supervisor Cavelli and a second by Supervisor Langenhan. Any further discussion? The agenda item, again, is from Extension Education Economic Development Committee and Human Resources Finance and Property Committee, an approval of a budget amendment to allocate up to $50,000 in American Rescue Plan Act, ARPA funds, for participation in the 2024 Uniquely Wisconsin Program, Resolution 30-24. Again, a budget amendment and does require a 2/3 majority vote. Any further discussion? Okay, seeing none, now we can proceed to vote. And we'll proceed. And the motion is carried, but is not unanimous. And we'll move on to item G, Human Resources, Finance and Property Committee, approval of the 2025 Annual Budget Revenue and Expense Assumptions, Resolution 31-24. Motion by Supervisor Pfeffrick and second by Supervisor Marash. Any discussion? Any discussion? Seeing none, we'll proceed to vote, and the motion is to approve the 2025 Annual Budget Revenue and Expense Assumptions, Resolution 31-24. And the motion is carried and is unanimous. We'll move on to item H, and if I could have a individual please read the motion, item 16. Supervisor Robinson, please.
I will move to go into closed session with a roll call vote pursuant to Wisconsin statutes, section 19.85, parent 1, parent E, for the purpose of deliberating and negotiating the purchasing of public properties, investing in public funds, or conducting other specialized public business whenever competitive or bargaining reasons require closed sessions, to wit, analysis of the county's right of first offer through landfill gas purchase agreement.
Okay, could you enter the motion on the computer, please? Oh, and the second is by Supervisor Zhang. Roll call is requested, so everyone please vote on the motion to go into closed session pursuant to the motion made and read by Supervisor Robinson. Supervisor Arstead? And the motion is carried and is unanimous. We'll be in closed session, and we will no longer use the mics. Please turn off all of the mics because they do carry outside this room.